Hi, this is Marian Mendoza and I will be discussing the labor case of Cebu Portland Cement Company as the petitioner versus Cement Workers Union Local 7A, LU, and Court of Industrial Relations respondents as my project of labor case analysis for labor law and legislation course. The Government Corporate Counsel for petitioner, Seno Mendoza Ruiz and Associates for respondents. The case we are going to analyze concerns the petition of Cebu Portland Cement Company about the decision of the Court of Industrial Relations to the case of Cebu Portland Cement with the Cement Worker Union. In the sinumpaang salaysay of the Cement Workers Union, Local 7-ALU, hereafter referred to as the Union, the CEPOC, as the petitioner made a verbal agreement regarding the implementation of the collection of a monthly agency fee of 1 peso from every employee of the plant regardless if they are a member of the union or not. Later on, CEPOC refused to honor the said verbal agreement, and because of this, the member of the union staged a strike. They managed to gather around 300 workers on March 24th of 1961 in the plant of CEPOC at Tinaan, Naga, Cebu City. CEPOC filed a complaint certified by the President of the Philippines to the Court of Industrial Relations regarding the said strike. The union, at the same time, made a complaint against the CEPOC about unfair labor practices and discrimination against their group regarding the alleged refusal to bargain of the company to the workers as per the verbal agreement made by both parties before. CEPOC also filed unfair labor practice charges against the union due to the illegal strike made last March 24 of 1961, leading to the employed threats, intimidation, and violence, which resulted in the death of one employee and physical injuries to several others. While the case was ongoing, the Labor Court issued a return-to-work order for the union members who had joined the strike. The affiliated workers were able to return to work on July 6 of 1961. However, based on the claims and evidence presented in the court, the union member workers were not permitted to work on Saturdays, Sundays, and legal holidays upon return, while non-union member workers and very few union members were still able to enjoy the said privilege. The union also claimed that there was discrimination against specific union members: Junicio Lapitan, Ponciano Mabatid, Vicente Sharza, Sabino Canillo, Fructuoso Hill, and Pedro Sanchez, regarding the appointment in the position. Records had shown that the said members were occupying the position of mixed control chemist at 195 pesos. On June 30th of 1957, they received a temporary promotion and upped their salaries to 215 a month. After that incident, WAPCO law was established and the employees had to submit their duties and were classified as construction material chemists, with range 34 at 259 a month. However, the petitioner had protested the said classification and had required the employee of CEPOC to a resubmission of the job description, which resulted in a lower salary of 183 and reclassification into senior chemical laboratory technician. Moreover, the union members claimed that discrimination was present in the form of biased schedule allocation to the members of the union. They claimed that union members were not permitted to work during the night, on weekends, and on legal holidays. Because of this, the union members were not entitled to night shift differentials, and on the contrary, the petitioner had claimed that the reason for the shift assignment and non-permission to work on Saturday, Sunday, and legal holidays were due to the shortage of coal and economic measure. CEPOC had presented that the company before and after the strike was operating at a loss and had met a financial crisis. The company had to change the operation schedule by assigning workers to work in day shift and only render at night if necessary. The petitioner stated that assigning of workers to work on weekends, legal holidays, and night shifts was based on demand and that paying for the possible extra wages to fulfill the request of the union member despite the small workload would lead to bad financial conditions. In addition, the union members was forced to use their sick leave and vacation leave. The petitioner claimed that the reason for the forced leaves was because of the crisis the company was facing. Regarding the issue of discrimination in the appointment of union members to permanent positions, SEPO claimed that the findings of the Court of Industrial Relations do not have any substantial evidence and should be revoked. The court gave its decision on November 6 of 1964, which was not in favor of the petitioner. The petitioner, Cebu Portland Cement Company or CEPOC, therefore, filed a petition to the higher court regarding the decision of the Court of Industrial Relations due to the following grounds: that they found that the issue regarding discrimination against union members, assignment and appointment of a permanent position is not supported by substantial evidence, and that the order for it to be revoked. Aside from that, SEPOC stated that the company has the authority for its employees and workers to take or use vacations and or sick leaves of absence whenever needed due to its finances, and that the Court of Industrial Relations discretion of not ordering the dismissal of the workers or employees who participated in the strike of March 24, 1961 service. Ruling of the Court of Industrial Relations on November 6, 1964, the Court of Industrial Relations issued a decision regarding the three cases. Here is the decision. The court has decided that the strike the union made was illegal due to the following reasons: unjust, trivial, and unreasonable. The court decided that the collection of agency fees from non-union members should not be implemented. The court has established that there was discrimination against the union from the CEPOC regarding working during weekends, Saturday and Sundays, legal holidays and night shift schedules, as well as in the appointment of a permanent position and associated salary to the 6 union members. Therefore, the court ordered CEPOC first, to pay the discriminated members the just and proper salary that they were not able to receive during the said period. Second, to change their shift assignment and has remained in the day shift. Third, to pay the 6 union members, Junicio Lapitan, Ponciano Mabatid, Vicente Sharza, Sabino Canillo, Proctuso Hill, and Pedro Sanchez, who were discriminated with the proper position and wage. Concerning discrimination in the assignment of work for Saturdays, Sundays, and legal holidays, it was known that before the said strike, union members were able to work during weekends and legal holidays and were given the rotational shift. However, after the issuance of return to work order from the labor court, it was clear based on the evidence that some of the strikers were not allowed to work during those days. The claim of the CEPOC regarding the shortage of coal and economic measure does not justify the measures made by the company regarding the work of schedule of the non-union and union members, showing discrimination against the strikers not having the privilege after the strike. The lower court agreed to the union with the possibility that the CEPOC supervisors must have informed the non-member what must be stated because if the employee submitted the same job description from the previous WAPCO conducted. The court asked why was there a change in the classification and salary range. The lower court had said that there was no substantial evidence that led to the biased treatment of CEPOC to the reclassification of the position. Regarding the forced use of sick and vacation leaves of absence every month, which was proven by the memorandum made by the CEPOC on April 4, 1961, the court has decided that CEPOC to restore the accumulated leaves which were forced to be used by the employees and to pay the wages that they have failed to receive. The court has ordered the chief of the examining divisions to facilitate the computation of the amounts which will be received by the affected employees and to submit a complete detailed report regarding it. Rulings of the Supreme Court. The higher court did not entertain the protestation of the respondents with regards to whether the strike should be legal due to the failure of an appeal to the decision of the lower court to be illegal. The main concern of the petition is whether there was discrimination against the union members by the CEPOC after the illegal strike last March 24th of 1961. With regards to the discrimination of working days, weekend and legal holidays, and work hours for night shift, the court stated that the petitioner has failed to point out the issue regarding the discrimination. Whether there is a shortage of coal and economic measures or not, there's no hiding fact that the union members were discriminated, considering the evidence shows that most of the union members remain on the day shift and were not allowed to work during weekends and legal holidays. With the judgment of the lower court to the presumption that a rotation of shift for all employees would have been proper conduct with which the company didn't comply during the said event, the higher court therefore concluded that the petitioner has failed to disprove that the findings of the Court of Industrial Relations regarding the case, therefore, the findings must be respected and followed. The union had claimed that there was discrimination in the appointment to the permanent positions to the 6 union members, Junicio Lapitan, Ponciano Mabatid, Vicente Sharza, Sabino Canillo, Fructuoso Hill, and Pedro Sanchez, and that during the resubmission of the job description to the WAPCO, non-union members were properly advised and informed by the superior on what is supposed to be written to their job description. The lower court then agreed with the union and against the petition. Upon the petition, the higher court dismissed the findings of the lower court because SEPOC had no control over the standards of WAPCO, and that the decision released by WAPCO regarding the position and salary was based on the duties submitted by the employees, and that the claims of the union and Court of Industrial Relations have no substantial and credible proof. Therefore, the petitioner is no longer obliged to pay the 6 union members for the lower court findings. The petitioner, SEPOC, stated that they might have the authority to force leave to its employees and workers to avoid accumulation with regards to their finances. Therefore, they must not be obliged to comply with the order of the lower court regarding the said issue. The lower court claimed that the made order was not due to the lack of authority of the company, but was due to the memorandum requiring the union member workers to use their 3 days leave every month that the company released last August 4, 1961, which has violated the return to work order of the labor court. The labor court has released this order for the strikers to restore their positions in the company, disregarding the dispute that arose due to the strike and releasing the memorandum the company has violated the order for the maintenance of the status quo in the relationship between the workers and the company, which the higher court agreed upon. SEPOC has a petition that the Court of Industrial Relations should have issued a dismissal to all of the members who actively joined the strike since the strike was considered illegal. The higher court declared that the fact that the strikers returned to work upon issuance of a return to work order by the labor court and there was no proof of evidence that all of the strikers had committed unlawful acts, therefore, the denial of the petition for the dismissal of the said employees. In cases where the employees is found to be guilty of committing an unlawful act, the company may carry out its jurisdiction of removing the said employee. To conclude the case, the court decided to modify some rulings of the Court of Industrial Relations regarding the petition of SEPOC about the discrimination of position with the 6 members of the union. However, the other issues will be handled accordingly to the judgment of the Court of Industrial Relations, to wit. Wherefore, with the modification that the petitioner SEPOC is not liable to pay the differential salary awarded by the lower court to the 6 employees, namely, the compliant, there being no discrimination employed by the petitioner in the appointment of said employees to their present positions, the decision appeal form is affirmed in all other respects. Accordingly, these cases are remanded to the lower court for compliance with the judgment herein. Cost against petitioner, Republic of the Philippines, Supreme Court, Manila, 1968. The decision was finalized on October 14 of 1968. In my opinion, the regulatory framework regarding labor code needs to be polished in the sense that it has extensive rules that cannot be applied in general for every company out there. Loopholes are being exploited by the corporations to abuse their employees. It is true that the laws regarding labor protect employees and prevent corporations from discriminating against their workers. However, the current laws needs to improve in order to become efficient and more effective. One example in particular that regards the case is the SEPOC forced vacation and sick leaves on the union members after the lower court decided to have a return to work policy. In my opinion, SEPOC manipulated the existing laws so that technically they are not breaking the law. However, the gesture them doing that showed otherwise and gave discrimination and bias action toward the union members. In conclusion, extensive revision regarding laws relating to the labor code can help the justice system become better. That is my opinion on the matter. In addition, the ruling of Supreme Court was the right decision as they practiced neutrality for both the company and union members. They also showed that they only acted based on the presented evidence. Both parties showed that they were at fault. Hopefully, other companies and workers showed a better example in creating a better working environment for the executives and the laborers. That concludes my analysis of the case. Thank you and have a wonderful day.